floor to Olena Sotnik, MP from Samopomich, and Alexander Banchuk, expert of the Center for Political and Legal Reforms. Actually, it was announced that we are going to introduce the draft law. Thank you. So the draft law number 2404, and eventually I would cover the principal norms of this new draft law. But actually, I think that Olena will focus on some political topics. You see, if we change nothing in the law on the prosecutor's office, it will bring us to the collapse in this structure since 26th of April. The old law will cease to exist and the new law won't be there. There will be no local prosecutor's office and no procuracy protection for the citizens. I would like to criticize the Parliament coalition. It's acting contrary to the coalition agreement, where it's stated that the coalition will take their efforts to implement the new law on the public prosecutor's office. My feeling is that the largest parliamentary fractions are going to take time until the last day and to say that the new law won't come into effect on time. You know, this is the principal threat. We'll be left again without any reforms in the public prosecutor's office structure. This new draft law number 2404/1 provides for several important things. First of all, according to this draft law, the reform process shall start on April 26th, and there is a detailed list of all the steps of the said reform. The competitions for local, regional, and prosecutor general office candidates within a year. It means that in the next 12 months, we should reset the prosecutors' offices throughout the country. It's a very specific list of actions provided by this new 2404 draft law. Another important thing is as follows. The draft law is going to implement the opinion of the Council of Europe experts, which will be moved on December 24 by COE experts after the existing law, current law, had been implemented, had been adopted. There are some suggestions for amendments which are for sure very unpopular to the current administration. It's about the competition on all the prosecutors' offices. Neither president nor current prosecutor general would like these amendments because they are going to limit their power. The new draft law also provides for shortening the prosecutor's office's headcount down to 10,000 in a year. I think that the community should understand that every postponement of these amendments is contrary to anti-corruption measures. If the new law starts being in effect since 26th of April, it will be a new situation where the prosecutors will be selected in competition. This will bring us to a unified mechanism of prosecutors' offices and anti-corruption bureau to fight corruption. We see that the president and the presidential administration are going to have the influence of a specialized anti-corruption forces in prosecutor's office. So now we are seeing a mix of influences and political wills from different offices, and it results in a high degree of the risk that we are not going to have any reforms in April. Thank you. Thanks. I'm Olena Sotnik from Samopomich parliamentary bloc. Alexander was right mentioning the new law under the risk of not coming into effect in April. It's related to the fact that two new prosecutors general, Magnitsky and Yarema, had the necessary mandates to prepare implementation of this new law, this new draft law, but they actually have done nothing, zero. Currently, all the prosecutors' officers are facing the fact that it's not possible to do in 1 month all the things that should have been done in 6 months to rearrange all the district and regional prosecutors' offices. The new law did not provide for the environment where the acting prosecutor general won't support this law implementation. We, on our part, structured this new draft law to be in compliance to European standards according to Council of Europe suggestions, and secondly, to provide the Prosecutor's General's office with the capacity to make the existing prosecution officers' systems compliant with these requirements. The basics are, first of all, competitions promised by everybody but not included to any draft law already registered in the Supreme Rada. And there are 5 or 6 draft laws like this. Our draft law is the only one not aimed at hindering the reform or postponing the reform by 6 or 12 months. We were forced to move this draft law and to suggest our recipe, our option to make this new prosecutor's office law to be effective. My political comment on the open competition for prosecutor's general office. It's actually the procedure similar to being used for the Anti-Corruption Bureau. There should be an independent commission with the representatives from the Parliament, Cabinet of Ministers, and Presidential Office. This commission will be independent, but at the same time balanced by presence of these 3 parts of its composition. It will move the candidates for the president to choose, and in case he chooses nobody, the commission will start working again. Actually, what is important is that there is a procedure that the community can see how the candidates are selected. If you remember, we, the Samopomich faction, did not support currently acting Prosecutor General, Mr. Shokin. It didn't mean we didn't like Mr. Shokin. We were opposing the fact that its This candidate was moved and voted upon in the parliament just in one day. In our eyes, the most important thing is openness and transparency. The community must know whom they will have for some time as their supervisor. Another important comment to make: the new public procuracy law is a sign of progress, and I'm grateful to Mr. Kожемякин, who aggressively supported this law and the Supreme Rada. At the same time, we still have the remnants of the Soviet system, like prosecutor's supervision. Our draft law cancels this function and leaves only two functions for the prosecutor's office. The first is process supervision, and second is representation of the state part in the court. There is nothing else for the prosecutor's or attorney's office in Europe, and nothing besides that should be here in Ukraine. We are trying to make the prosecutor's office functions and headcount compliant with the European norms, whereas currently we have almost 4 times more prosecutor officers as compared with Europe. We should make a kind of investigation or audit about their function and about the necessity of some or other functions and prosecutors in the current situation. Another thing that should be withdrawn is some preferences and incentives which have been used to exert pressure on the prosecutors, like providing with free residentials. We think that the same thing should be done to all public servants. What should be done is just to provide the public officers, public servants with relevant wages, relevant salary, and everything else is unnecessary. We are also trying to undermine the range systems in the prosecutor's office. Everything is reflected in our draft law, and we'll be insisting in our Supreme Rada on moving on this draft law. It's enough to pretend that we are moving the reforms. The MPs should support real-life reforms which allow us to fulfill our obligations against society. We understand that there is constitution and the necessary amendments to change the court systems, but in this case there is no necessity at all to change anything in constitution. We're going just change the law and start working. What I would like to add before we move to Q&A session is as follows. You may have paid attention on Mr. David Korolidze's words. Actually, what he does is to translate PowerPoint presentation, but what we are trying to say to do is to translate David's presentation into the legal language. Up to now, we only heard some words from different MPs, and for instance, our colleagues in the parliament moved the draft law, postponing the reforms for another 9 months. I don't think it's a good thing for society, and it's not the kind of initiative to be accepted by the society. But we understand that this competing draft law was moved by the presidential fraction. Well, I have the question. You mentioned David. Did you have a meeting with him, and what he communicated to you? because he's not present here, maybe you deliver his opinion on the efficient resolution of current situation. Well, please understand that our positions, our points of view are well coordinated, but we still have differences as to who is going to carry out this competition. In our opinion, we should establish a temporary competition committee to carry out the competitions on district, regional, and national level. So they think that the Prosecutor General should form these commissions, but I don't think that we can be too content with the Prosecutor General initiatives on changes in our society. You see, the Prosecutor General's office has no constitutional right to move draft laws. So what we do, we just coordinate our activities with the Prosecutor General's office. We keep in touch, believing that they are also willing to move ahead the reforms to fulfill their obligations. Well, actually, we're really grateful to Deputy Prosecutor General, and we are grateful to the Prosecutor General's office because they are, well, they have people open for cooperation. But this team is not so numerous. They just physically are incapable of carrying out this competition throughout Ukraine. It's over 40 million of population, and what we move in our draft law is a kind of mechanism supporting this initiative. We do not agree with the Prosecution General's office because they are trying to keep control in their hands, but we don't think it's an optimum option. Just introduce yourself and ask a question, please. I'm Anton Ovcharenko from Судебно-юридическая газета, judicial and legal newspaper. My question is to Elena. I just haven't seen anything of the kind in the supplementary letter, but found the following statements from stipulations in the draft law. It's about the National Prosecutor Officers Academy. As I understood from the draft law, it was suggested to leave the special preparation to this institution and do not leave the academic and scientific functions to them. So my question is rather formal. If this academy is not related to academic circles, it is not intended for education, why it's called academy? And the second part of my question, the draft law has the ambitious heading, adaptation to European standards and so on. As far as I know, European countries, except for Russian Federation, do not have any institution involved in the prosecutors, public prosecutors training. The institutions in Italy and France and other countries are rather involved in training both prosecution officers and the judges. Don't you think it's advisable to join these two universities or these two institutions for judges and the prosecution officers? Why should we waste the state budget costs to support two similar institutions? Thank you. I will take time to answer. It's important. There is nothing to do about the name. We carried out some consultations and we decided that to call it like a training center wouldn't be compliant with the essence. What can I say about the draft law? We postpone implementation of the requirement for 2 years of experience in the prosecution office for some time to enable the lawyers able and willing to work to replace those who are neither capable nor willing. I think you won't object if I say that there are some specific features in prosecutor officers' work as compared to, say, regular lawyers. We must train the lawyers to understand their specific features for a short time, and after that it will be possible to improve the skills of this new stuff. So I think the name is irrelevant. What is relevant is the essence. It's, kind of an institution similar to Police Academy in the United States, aimed on practical skills. It shouldn't be involved in scientific research. We have enough universities, Academy of Science, and so on. We have the experts to be involved in scientific research there. It's actually a training center aiming at quickly adapting the new people or the people who are making their career to the new standards. My next point is about similarity to European countries. I wouldn't say that we are too ambitious, because the law itself was praised by European officers as initially European-based. What we did was to adjust the topics criticized by the Council of Europe to these suggestions, and our draft law is aiming on making the new law 100% European, and I think we did it. Alexander, you may comment my words. Well, yes, thank you, Elena. My perspective is as follows. You were right mentioning that between first and second hearing, there was a suggestion to create a justice school on the basis of 2 training centers. It was my point of view too. It was related to some saving, but the representatives of the judge who objected to this because they said they had enough judges. That's why we decided to leave this academy, but have it, I would say, truncated to regular size. So this is our perspective on this institution. Nothing prevents us from joining these 2 institutions in the future. It may be better for the state budget to have only one training institution for both prosecution officers and judges. However, you should consider that according to Constitution, the prosecutor officers are not related to justice as is. In Spain, Portugal, and Italy, there is a kind of master training institutions, and they don't have any problems in moving people from the prosecutor's office to judges and another way around. That's why they don't have any problems related to training judges and prosecutor officers in one institution. But our environment, our legal environment, is a little bit different, and as our constitution does not support considering the prosecutor officers as a part of justice structure. So that's why we cannot join these 2 institutions. When the constitution changes, we'll be able to do it. You mentioned several alternative draft laws, and and I understand that there are some lobbying activities to move these draft laws. Do you have any plan Bravo in case somebody else's draft law is adopted? Well, yes, we are also considering the best option and the worst option. The worst option is if draft law moved by Mr. Lutsenko is adopted, because it really will result in postponing the prosecutor office's reform for a year. It's really the worst option because it will bring to zero all our efforts and our Georgian colleagues' efforts to change this system. It will mean that an outdated system will be there for another year. Nobody knows what can happen in a year. We'll understand that in the times of dignity revolution, the prosecutor officers were the people provide moving for the activists' arrests and so on. I think that the society will be against such an option, and I would not suggest that my coalition colleagues insist on this scenario. Another draft law is relatively good because it puts to order some points about positions and territory. So if our draft law is not adopted, we'll move amendments to alternative draft law to bring it to the structure helpful to reform and change now existing prosecutor officers system. That's why we are here. Actually, we are now involved in a promotion campaign to have people exert pressure on the parliament members to make this law implemented, to make this law working, despite the fact that the current system is opposed to this. Well, actually, we almost understand that, as a matter of fact, we are talking now about a couple of parliamentary session days. In this short time, we must decide. We have only two options, actually, or to postpone the reforms, either postpone the reforms or to move ahead quickly. Actually, you know, we are used to changing things quickly, as we changed the constitution, as we changed the processual code, and so on. It's just close to 15 years parliamentary tradition. You know, we are facing an interesting thing in our parliament. Our draft law package will be moved there about law enforcement structure. Some draft laws are very interesting, some doubtful. There are also the draft laws that we have to see yet. So I think next days and next weeks in the parliament will be very exciting. We must focus. We must not scatter our attention, and all the society should exert pressure on us. You know, I think we'll have a problem in selecting the candidates for Anti-Corruption Bureau, for the chairman of Anti-Corruption Bureau, and that situation will be exemplary for similar situations related with the prosecutor's office and the draft laws to be moved. We'll be seeing different branches of administration moving ahead, and I wish you all the success in your implementation of your reform. Thank you.